Afternoon. My name is Mike Ruiz, and I'm excited to be here with our expert faculty and all of you today. On behalf of St. Louis University School of Law, I want to thank you for joining us for today's webinar, Health Law and Policy in the Pandemic. This webinar is a second edition of our Law in the Time of the Pandemic series hosted by SLU's School of Law. Before we begin, a couple of quick announcements. As we mentioned in the email with the link to the webinar, if you are having any technical issues throughout, please be sure to email alumni@law.slu.edu. We will be monitoring that account throughout the program. Additionally, please submit questions to the panelists using the chat function. If your question is for a particular panelist, please include that person's name with your question. And just a quick overview of today's CLE program, SLU alumnus Dr. Brent Ibarra will give a quick introduction before the three sessions, which are presented by faculty experts, Professor Robert Gatter, Professor Santos Rutschman, and Professor Sidney Watson. After that portion of the CLE is complete, the panelists will join us for a live discussion. And thank you again for joining us today. Now it's my pleasure to introduce Dr. Brent Ibarra. Dr. Ibarra is System Director of Accreditation and Quality Assurance for Lee Health, the largest healthcare system in Southwest Florida. And during his career, Dr. Ibarra has served as Director of a Clinical Research Facility, a Hospital Director of Operations, and a Corporate Director of Research Compliance. He is recognized for his ability to bring together multidisciplinary teams within highly matrixed healthcare organizations. He also built nationally recognized centers of healthcare innovation. Dr. Ibarra is a registered patent attorney, a member of Mensa International, and a fellow with the American College of Healthcare Executives. He is an advocate for disability rights, served as chairs of the Special Education Advisory Committee for Virginia Beach City Public Schools, and is the author of the book, Public Health Law and the Built Environment in American Public Schools. Dr. Ibarra received the Alumni Merit Award from the College of Public Health in 2019, and Dr. Ibarra has the rare distinction of being a triple grad of St. Louis University, earning 2 degrees from the College of Public Health and Social Justice, and his JD from the School of Law. Thank you so much for being here today, Dr. Ibarra.
Thank you, Mike. As Mike mentioned, this is a second of 3 session webinar. Today's webinar focuses on the health law and policy issues that have arisen during this pandemic. This is an especially important topic because we have seen public health experts frequently in the news. We've all experienced the lockdowns and closures of certain high-risk events, and we're all anxiously watching the vaccine race as it unfolds in real time. In the process, we're having to process these events and their legal implications quickly. We are fortunate to be joined today by our experts from the Center for Health Law Studies here at SLU Law to help us make sense of these developments. The Center for Health Law Studies is renowned across the country and consistently ranked the #1 health law program in the country by U.S. News and World Report. The center helps to connect students, practitioners, and academics focusing on the study of health law. These talks were pre-recorded so we can make sure to get the most information possible into the 10-minute time frame for the talks. Then we'll have time for questions, which you can enter into the chat. First, we'll hear from Professor Robert Gatter, who will speak to us about substantive due process review of public health measures during an emergency. His presentation describes the balance between protecting public health from the spread of disease and individual rights, covering areas such as quarantine orders, drawing from his own experience as a member of the St. Louis County Health Department's COVID-19 response team. From there, we will turn to Assistant Professor Santos Rutschman, who is a member of the Center of Health Law Studies at SLU Law and the Weffel Center for Employment Law. Her presentation is entitled The Vaccine Race in COVID-19. Her presentation will cover some of the practical issues involved in vaccine trials and explain the role of intellectual property in the race towards a vaccine. Finally, we'll end with Professor Sidney Watson's talk, Medicaid, Federalism, and Health Equity during the COVID-19 pandemic. Professor Watson is the Jane and Bruce Robert Professor of Law and the Director of the Center for Health Law Studies. Medicaid is our joint federal-state program safety net health insurer. This talk focuses on the role that Medicaid is playing during this pandemic, how Medicaid's federalism allows states to respond quickly in times of emergency, but how federalism also creates health inequalities, particularly for people of color. With that introduction, let's get started.
Hi, everybody. I'm excited to participate in this webinar, telling you about some of the work I've been writing and talking. So my presentation focuses in on the right legal standard to use to hold courts accountable for enforcing individual rights while at the same time protecting public health. This ends up being about substantive due process and specifically not just what level of scrutiny, but how do we apply any level of scrutiny when testing the constitutionality of a public health measure. Just as a quick background, substantive due process aims at assuring that the government has sufficient justification for any actions that it takes that tend to deprive individuals of liberty or property under the 14th Amendment or under the 5th Amendment to the Constitution. There are more than these two levels, but these are the primary two levels and the only two levels that I'm going to talk about during this presentation. Rational basis testing is the default. If no other standard is shown to apply, then the default standard is rational basis testing. And it says that a government's action is constitutional if it is rationally related to a legitimate governmental interest. The burden is on the individual challenging the constitutionality of the state's action to show that there is no rational basis whatsoever. Compare that to strict scrutiny. Strict scrutiny applies whenever the liberty interest at stake is deemed fundamental. And then the burden is on the government to show that its action is necessary to achieve a compelling state interest and that it is drawn up so narrowly so as to achieve that purpose without infringing unnecessarily on personal liberty. In the public health context, there are times when rational basis testing, you would assume that rational basis testing applies, and times when strict scrutiny applies. So, for example, where the freedom to move about is infringed by a quarantine or isolation order, or where bodily integrity would be infringed because an individual is vaccinated or they're having blood drawn from them, or because they're sharing personal medical information with public health officials. All of those are likely fundamental infringements on fundamental liberty interests, which triggers strict scrutiny. Meanwhile, there are plenty of public health measures that don't trigger strict scrutiny because they don't involve infringement of a fundamental liberty interest. For example, restrictions on smoking in public, taxing alcohol or cigarettes, setting speed limits, requiring individuals to wear seatbelts or motorcyclists to wear helmets. But some of this is now thrown into doubt. And it started not right now with COVID, but instead with Ebola. There was a case, a really famous case of a nurse who had volunteered to treat Ebola patients in West Africa. And when she returned and re-entered the US through the Newark International Airport in New Jersey, she was placed into quarantine. Later, she sued, claiming that the quarantine violated her civil rights. And in ruling on the case, a federal district court said strict scrutiny apply. The only thing that was clear at the time of the quarantine was a case known as Jacobson, which imposes a sort of rational basis test. It says that a public health measure taken during an epidemic has sufficient justification as long as it has a real and substantial relation to the state's effort to prevent the spread of the disease. And the court ruled that quarantine in her case did. Whether it did or whether it didn't isn't the issue here. Instead, the interesting issue is that it moved what we would normally think as a liberty restriction through quarantine isolation out of the strict scrutiny category and into the rational basis category, a much lower test with the burden falling on the individual instead of on the state. So the question then ends up being, what's due process standard applies to COVID-19 actions taken by, and how is that standard applied? So the Fifth Circuit in early April ruled on a case involving a Texas state order that forbid medical providers from providing any care that was not necessary to save the life or limb of the patient. Abortion providers had sued, claiming that the Texas order couldn't apply constitutionally to individuals, pregnant people seeking abortions, because that would be an undue burden on their constitutional right to pursue an abortion. And the Fifth Circuit said, no, this is during a pandemic. So that standard abortion, the standard for abortions, undue burden, does not apply here. Instead, it's Jacobson that applies. And it's simply a matter of asking whether the Texas state order bears a real or substantial relation to the public health crisis. Given that it does, we are finished, said the Fifth Circuit. That was in early April, and at least about 30 federal and state courts have cited positively to that standard, to In re Abbott, for this particular holding. So let me tell you a little bit about Jacobson, this case that both the New Jersey court in the Ebola case as well as the Fifth Circuit cited. It involved public health officials in the city of Cambridge. Smallpox, they said, was entering the city, and they required that all adults in the city get vaccinated against smallpox. An adult resident of the city of Cambridge, Henry Jacobson, refused to do so, and he was fined by the city $5. And he challenged both the fine and the underlying law as being unconstitutional. He said that the city doesn't have a sufficient justification for requiring the vaccination in the first place, and therefore it violated his 14th Amendment right that no state shall deprive any person of life, liberty, or property without due process of law. And it went all the way to the Supreme Court. The Supreme Court made two important holdings. One was that states have the police power, and this was a legitimate action. The requirement for smallpox vaccination was a legitimate action under the police power. At the same time, the court said states can't act under the police power in such a way that deprives individuals of their protected liberty interests. So the court recognized that it now needed to decide when is a liberty infringing action by a state so infringing that it deprives an individual of liberty without due process of law. And what the court said was that the action must bear a real and substantial relation to the public health goal. So in that case, the court ruled that the city's requirement of a smallpox vaccination at a time when public health officials believed that the vaccination would work and that smallpox was entering the city, that requirement bore a real and substantial relation to the public health goal of preventing the spread of smallpox in the city and thereby protecting the health and safety of the city's population. And that's how the case ended. Well, the Supreme Court has not gone back and amended that or overturned that holding from Jacobson, even though the standards for substantive due process developed substantially since 1905. As a result, there's many courts that claim Jacobson still applies today. It applies whenever we're talking about a public health measure that's taken during some sort of public health emergency. So as a result, courts like the Circuit have said, I have to follow Jacobson, and Jacobson sets a pretty low bar. It's just real and substantial relation. So that's why we see this. On the left-hand side is the language from Jacobson, real and substantial relation. On the right-hand side, we see it appear again early on in this pandemic in the Fifth Circuit. We might just be stuck with this. It might be the wrong standard, but until the Supreme Court rules on that, we need to have a contingency plan about how to apply the real and substantial relation test, rational basis test, to the many challenges related to today's pandemic or the next pandemic if the Supreme Court never addresses the issue or addresses it and does not overturn it. So why do we need to address it? Because so often we recognize that the fight is really over the level of scrutiny. I think that's a myth, but there are many who would say deciding this substantive due process standard actually ends up deciding the case. So there's a risk that courts will do nothing but rubber stamp these. Well, real and substantial, that's a really low standard. So we say that the public health officials have met it. And after all, who are we as courts, ill-equipped to understand how public health works, to question the expertise of public health officials who thought that this was necessary? So what's my argument? Instead of our concern about the level of scrutiny, at any level of scrutiny, we need to make sure that the inquiry is sufficiently focused. So here's a set of factors. The factors require the court to probe a bit. How is the disease transmitted? How does the particular disease, based on the best medical evidence that we happen to have available today? What happens to some? Will they infect others? How likely is that to happen? Is there any evidence that the state's action will be effective at either preventing the transmission or lowering morbidity or mortality? And in light of these questions, now let's ask, is there a rational public health or medical basis for the government's action? This is consistent with general rational basis testing, right? I haven't changed anything here. The only thing I've done is in this bottom bullet point, the burden, while it's still on the individual who's challenging the constitutionality, all they really need to do is rule out rational medical bases, rational public health bases. If you rule those out, then there really should not be a finding that there was a rational basis for the state's action at all. If you want to read more about this, I got the focus scrutiny test from a 1989 article by Scott Burris, and I've updated that standard and pretty much this presentation in an article that will be forthcoming in the Washington University Journal of Law and Policy. Stay safe, and thanks for watching.
My name is Santos Rutschman, and I'm an assistant professor of law at St. Louis University. Today, I'm going to be talking about COVID-19 vaccines and some of the legal implications of their development and hopefully their distribution and administration before too long. Before I get to the legal side of things, legal and policy side of things, let me just put this vaccine race that I think we're all now keenly aware of in context, because it's a very unusual vaccine race, and there are some legal implications, I think, that stem from this, the odd contours of this vaccine race. So COVID-19 is unusual as a public health crisis. You've seen it compared to major outbreaks, to major pandemics in history. But this is really, I think, the first time that we have a truly global vaccine race. Never before have we had, as we did by summer 2020, over 140 different development projects focused on COVID-19 vaccine candidates. Normally, there's a handful of vaccine candidates that get to be funded and developed during the early stages of an outbreak. So 140, 150, 160, kind of depends on how you count. It's very, very unusual. Normally, drug development in general, and certainly vaccine development, takes years, if not decades. It's very costly. It's time-consuming, and all of this has several implications from a regulatory/legal perspective. So let me shift from the context to those implications, and what I'm going to try to do today is to just point out some things that are already of interest in this race that we know are going to be different because of how unusual this vaccine race is, but some emerging problems that we are likely to be facing at the distribution level with regard to these vaccines. So from a regulatory perspective, when you have this type of expedited, heavily populated global vaccine race, there's a tension, there's an inherent tension between the ways we've designed regulatory systems to look at data produced over large periods of time and how concentrated temporally this race is. There are mechanisms that allow regulatory authorities like the Food and Drug Administration in the US, the European Medicines Agency in Europe, to consider drugs, even outside the context of a pandemic, to consider drug applications in an expedited fashion. And that's what's going to happen with the COVID-19 vaccines. As they approach the licensure stage, we are going to see the FDA deploy some of these expedited review mechanisms. There are different ways in which the agency can approach this, but the basic way to bring something to market based on strong indications of safety and efficacy that an agency can rely on, specifically the FDA can rely on, is called an emergency use authorization. This means that there is sufficient data, sufficient indicia that a particular product, in this particular case, a vaccine, is going to do what we expect it to do and will not trigger substantial harmful effects. Now, this will be supplemented if we get past these emergency authorizations. This will get supplemented by additional studies. So, for instance, SLU, St. Louis University, which has been involved in the clinical trials for some of these candidates, is scheduled to continue studying these vaccines, hopefully past what the duration of the outbreak might be. So these are health products that are going to be monitored for years. But the bottom line is that from a regulatory perspective, we are going to be relying on some not clinically significant endpoints, but sort of surrogate endpoints, secondary indications that might provide early insights into the efficacy and safety of these vaccines. So this is something that our regulatory systems are designed to do. In the field of vaccines, some people are a little bit uneasy about how they might be reviewed and approved, because really emergency use authorizations were not designed with vaccines in mind, and we have really not used them before for vaccines like these. So we're seeing the regulatory system doing what it's supposed to do, accelerate review of new products because of how important that is from a public health perspective, but also because of the particular configuration of this vaccine race. But there are some ethical considerations and medical / scientific considerations which we'll be learning about as we do this for the very first time. So that's sort of the regulatory background to this vaccine race. So the system will function, will assure us, hopefully, that these vaccines will be safe and that they will be efficacious or relatively efficacious. That's all we can ask for at this point. And hopefully these vaccines will come to market. Now, here's the thing. Vaccines, as I've been describing them, are primarily public health tools. We need them to either lessen the effects of the outbreak or to prevent this continuing cascade of new cases. So they're basically public health tools and tools for public health interventions. But they are also forms of technology. And as such, they are covered by the same types of rights that apply, quite frankly, to our cell phones or to other technological products, even outside the biopharmaceutical space. So the branch of law that I'm thinking specifically of right now is intellectual property. Intellectual property is a system of rights that are granted by the state in exchange for the production of information about an invention. In this particular case, it will be a vaccine. And in exchange for the production of that innovation and disclosure of information associated with that innovation, you, the inventor, you get a right. You get a right, or a bundle of rights, I should say, that regulate the things that other people, would-be competitors, can do with your goods for a particular period of time. Right now, the period of time that in this case, the patent grant will cover is around 20 years. It's formally 20 years, in practice slightly less than that. What it means in practice is that absent some form of public or joint public-private ownership of a vaccine, if the inventor, if the company that has a patent or several patents over a vaccine, and we know these exist already in connection with COVID-19 vaccines, if they have that patent for the period through which the patent is valid, they get to control competition. They get to exclude would-be competitors in principle from manufacturing the same vaccine and, say, selling it at lower cost or at no cost or free of charge, for instance. So this is a prerogative that they have that comes with the fact that they've been granted or will be granted a patent. So this is something that people like me are monitoring right now, the patent landscape, and figuring out how these vaccines, again, public health tools of extreme importance, may be and are covered by patent rights. I've mentioned already competition. Patent law is a way to limit competition for a period of time. It's part of that sort of prize-like a bundle of rights you get for having innovated. So you've done something good, and here's your patent. But if misapplied, or if taken just in a very formalistic or literal way, a patent might come at a cost to consumers, in this case to patients, and to public health. We don't know at this point, and we won't know for months, what the status of these vaccines is going to be and what the price will be. We have an early indication from a drug, so not a vaccine, but a drug called remdesivir, for which we know what the prices are likely to be. And we're talking about a 5-day course of treatment priced at over $3,000, even negotiated prices through Medicaid and Medicare. So the concern when you have patented technologies and pharmaceutical companies have the ability to exclude would-be competitors is that they might overprice these vaccines. Nothing else, from an optimal public health perspective, assuming we have enough vaccine doses, we want as many people, as many indicated people as possible to have access to these vaccines. And we don't want anybody who's indicated and willing to take a vaccine to be excluded from having it for pricing reasons. So this is an emerging concern. Is there a solution? Yes, there are many solutions in our legal system, but there are some causes of concern. Here's a couple of solutions that we know for sure exist in the US. First one, the patent law itself, the patent code, contains provisions that allow the federal government to do certain things in connection with patent rights over technologies like vaccines. For instance, if there has been funding or partial funding coming from a federal agency, then that federal agency can march in, can license that vaccine on a non-exclusive basis to other competitors. So you don't take the patent away, you don't eliminate the patent right, but you limit part of the right, part of the bundle of rights by saying until everybody who needs the vaccine has it or has access to it, others can manufacture this vaccine on a non-exclusive basis. It's possibility number one. Bad news, the US has never done this. The federal government in the US has never elected to do this with other public health crises. So the odds of success here might be somewhat limited. Second possibility, and we learned this already during the COVID pandemic because this one has been invoked, is the Defense Production Act. This is something that has been primarily used in the context of wartime or preparedness for warlike events, but it's something that has been suggested could be used to compel the production of vaccines, that the federal government could use to compel the production of vaccines by others, other than the patent holder, if need be, because there's a crisis going on, so the government has that ability, and so far there have been some indications that perhaps the government will be willing to do that. Third option, at least one vaccine candidate we know about seems to be co-owned by NIH, the National Institutes of Health, so the federal government, and a pharmaceutical company. In cases of intellectual property co-ownership, and if that happens to be the leading vaccine candidate, the one coming to market first, the federal government can actually find ways to produce the vaccine and sell it, more cheaply than the pharmaceutical company might because of this co-ownership relationship, and they don't need consent from their co-owners. So there's yet another possibility. It remains to see if in terms of the political economy is viable, but that is also another possible pathway. And then finally, another patent law-based solution, Section 1498, 28 USC, allows for government use of patented inventions, particularly in contexts like this, in which there is a public health crisis. Commentators like Amy Kapczynski have provided a blueprint of how this section can be used in connection with hepatitis C drugs, and this strikes me as another area in which we could use existing law provisions, existing patent law, and beyond patent law provisions to make sure that if we figure out the vaccine race from a scientific and technical perspective, that we actually get to distribute these vaccines as widely as possible, and that no one is excluded because of economic considerations.
I want to welcome you today to this series on Law in the Pandemic, where I'm going to be talking about Medicaid, federalism, and health equity. As I'm sure you all know, Medicaid is our joint federal state safety net health insurance program that provides access to coverage and care for millions of low-income Americans. During public health emergencies, we need a safety net, whether it's a tornado in Joplin, a hurricane in South Louisiana, or the COVID-19 pandemic. Public health emergencies disrupt healthcare delivery and wreak havoc on the economy, jobs, and employer-sponsored insurance. We need Medicaid to adapt quickly to new and different demands on services during public health emergencies. And Medicaid gives states great flexibility to do that. State Medicaid programs have used this flexibility to pivot their Medicaid programs to attempt to respond to the different and new unique demands of COVID-19. They've made it easier for providers to enroll. They've increased provider payments. Some have removed prior authorization requirements. They have expanded the use of telehealth. However, the flip side of state flexibility is inconsistency across states. States are doing a lot of different things to respond to COVID-19, and we don't yet know which emergency response policies are protecting access and continuity of care. We do know, though, that we need Medicaid to be available to enroll newly insured people so they don't end up in the ranks of the uninsured. So I want to focus this talk on two stress points related to Medicaid eligibility and Medicaid federalism. One stressor arises every time we have an economic downturn, and Congress has already taken steps to address it. The other one relates to the Affordable Care Act's Medicaid expansion for low-income adults, and I'll talk about that second. But I want to put on the screen here some PowerPoints that we can look at as I talk. Because when we talk about Medicaid federalism, we often refer to it as cooperative federalism. And that's because Medicaid federalism is about generous federal support for Medicaid. Congress offers states federal funds, and when states accept these funds, they agree to operate their programs in compliance with federal law. Sometimes we call that cooperative, sometimes we call it voluntary. From a state's perspective, it means that they get generous and uncapped federal funds to help pay for Medicaid covered services. We call that the federal match. The Medicaid statute refers to it as the Federal Medicaid Assistance Percentage, the FMAP. Most services, the federal match ranges from 50 to 83%, depending on the state. Wealthier states are guaranteed a 50% match. Poorer states get a higher match, which can go up as high as 83%, depending upon the economic circumstances. And then other services get an enhanced match. The one that most people are familiar with is the enhanced match that states get for the Affordable Care Act expansion adults. Initially, that was matched at 100%. That means that the federal government paid the full cost for covered services for Affordable Care Act eligible adults for the first 3 years. Now the match for them is 90%. The federal match for administrative services is the same for all states, and it's 50% match. And I want to stress the fact that there is no cap on the federal match. So when we get into times of a public health emergency and economic downturn like we are in now, states are guaranteed that they will have federal matching funds to help them. They don't have to go it alone. And that's important because Medicaid spending is counter-cyclical. What that means is when the economy is bad, Medicaid enrollment goes up and Medicaid costs go up. But when the economy is bad, state revenues go down. They don't have as much money. Right when we need Medicaid most, it becomes hardest for states to figure out how to fund their share of Medicaid. And we run into this problem every time we have an economic downturn. And over time, Congress has developed a two-part federal response that supports states' programs during economic downturns. And that's what Congress has already done in the Families First Coronavirus Response Act. That was the first piece of legislation that got through Congress in March. And in Section 6008, Congress addresses Medicaid. And it's Medicaid federalism, it's Medicaid spending as we typically see it. Congress offered states a 6.2% federal match increase on most services, those ones they normally get 50 to 83%. And it's conditioned on states doing a couple of things. One, maintain Medicaid eligibility enrollment for the duration of the public health emergency. Not cut eligibility, not impose more restrictive eligibility procedures, not charge higher premiums. Really, specifically, not disenroll anyone in Medicaid except if they die, move out of state, or request to be removed. The other condition that Congress put on the FMAP increase is to require states to cover COVID-related testing, COVID-related services, and COVID-related treatments, including vaccines at no cost. This is really important because not all states covered COVID testing, particularly vaccines for all populations, and the Families First Coronavirus Act requires that it do this. This is a very typical use of Medicaid federalism. Congress offers an enhanced additional federal funds in return for asking states to do something additional. And in this case, Medicaid federalism has worked. Every state has accepted the offer of an increased match and has guaranteed that they will not cut eligibility or enrollment during the public health crisis, and that they will cover COVID testing. But you know, there's a problem. We know that going into this COVID health crisis, that eligibility enrollment policies vary greatly across states. And because of this, millions of people are going to fall through the Medicaid safety net. And that's really a statement about the Affordable Care Act expansion. In 2010, the Affordable Care Act expanded Medicaid coverage to include low-income, non-elderly adults. However, in 2012, the Supreme Court made expansion voluntary for states, declaring that the expansion could not be mandatory. That was unconstitutional. What the Supreme Court said was that Congress can offer states the enhanced federal match, but it can't make them take it. And that's where we are today. Those 12 orange states you see on the map have not expanded Medicaid to cover low-income adults. Before the COVID pandemic hit, there were 2 million people living in non-expansion states who could not get Medicaid coverage because their states had not expanded Medicaid. They could get Medicaid coverage. Their states did take the expansion. Early estimates with the COVID pandemic is that there will be as many as 20 million people caught in this COVID-19 downturn who will lose employer-sponsored insurance and who will not be able to enroll in Medicaid because their state did not expand Medicaid. And the map is important because it's important to realize that these states are primarily deep southern states. They are states with high proportions of Black and brown people. They are states with stark racial disparities to begin with. They are states with stark economic disparities based upon race. And they're states that have a history of slavery and Jim Crow laws. Medicaid expansion in other states has narrowed persistent insurance coverage gaps for people of color compared to white people. We need Medicaid expansion in this time of COVID-19. I want to end by suggesting that we need Congress to use Medicaid federalism and Medicaid's generous federal match to encourage these states to expand Medicaid. I urge Congress to offer these states 100% federal match for the first 3 years if they take up the Medicaid expansion. That is what the Affordable Care Act did for states that expanded early. We need to do that for late expanders because we need to keep this discussion about the importance of Medicaid expansion in this time of COVID-19 on the table and in the public sphere. Thank you. I look forward to talking to you in the question and answer period.
All right, we are live now and excited to begin the discussion portion of today's CLE. As a reminder, if you have questions, please add them to the chat throughout the remainder of the event. And I'd ask Professors Gatter and Watson to join us in the video so we can start the question session in just 1 minute. I want to thank St. Louis University School of Law for hosting this webinar on health law policy in the pandemic and for inviting me to moderate this session. As a healthcare executive, I see firsthand every day how health law and policy intersect mostly with positive public health outcomes. However, the pre-pandemic playbooks we have in our hospitals could not have anticipated the economic or public health challenges that this virus has created in the few short months since its emergence. COVID-19 has strained an already weakened healthcare system, and gaps are expanding in the frayed public health safety net. Increased unemployment has increased the number of uninsured patients, and many hospitals with already thin margins are now operating at significant losses. State and local officials are fighting an invisible enemy with their limited arsenal of police powers to protect the health, safety, and welfare of its citizenry. As a novel virus, there is no natural immunity, and our best hope is to flatten the curve and push as many people as possible in the tail of the curve out past the approval of a safe and effective vaccine. Flattening the curve requires unpopular state actions. Deploying a safe and effective vaccine requires large randomized placebo-controlled clinical trials. Vaccinating and treating the uninsured requires funds that could be made available under Medicaid. Professor Gatler's presentation provided some insight into the balancing act between the state actions and due process rights during this pandemic. Professor Santos Rutschman's presentation explains the regulatory web that multiple vaccine candidates are navigating with the hope that at least one safe and effective vaccine exit clinical trials without IP protections that would limit its mass production and global distribution. Professor Watson's presentation helps to understand how we might fix the safety net that has been significantly weakened by COVID-19. I'm sure there's many questions for our presenters, so please add them to the chat. Let me start with a question for Professor Gatter. All right, Professor Gatter, is the real and substantial relation test from Jacobson different from the traditional, the rational basis substantive due process test?
Well, thanks, Brent. Thank you for being here and helping us host this. The answer to that question is that it's roughly treated the same. It hasn't been developed very much. Right now, the most insight we have about the real and substantial relation test and how it would be applied is actually in the In re Abbott case. There was a lot of back and forth between the trial court and the Fifth Circuit the Fifth Circuit exercising a writ of mandamus, which is an extraordinary remedy for appellate courts at two different times as the case went back and forth, and it does flesh out a bit about how the Fifth Circuit was seeing the application of the real and substantial relation test. My estimation is that it's treated as pretty much synonymous with what we're all learned in law school about rational basis testing. And so that's how I'm treating it for now, but time will tell. It's really something that's oddly evolving now, even though the case it comes from is from 1905.
Thank you. Professor Watson, when you talked about Medicaid expansion, you didn't mention Missouri. What is the status in Missouri? How would your proposal impact the state of Missouri?
Missouri was one of the 3 states on the map that has adopted the Medicaid expansion but not implemented it. I think as many in the audience know, we had a ballot initiative that passed on August 4th, and the state now has until July 1, 2021 to implement the expansion. I certainly would urge Congress to include in an enhanced federal match for Medicaid expansion states like Missouri and Oklahoma, Nebraska, Idaho would be another that are latecomers to Medicaid expansion. We know that the 100% federal match has helped states, that Medicaid expansion has not hurt state budgets. In fact, it has helped state budgets. But I think in terms of the ongoing controversy and the need for Medicaid expansion, extending 100% match to Missouri makes sense.
Thank you. Professor Gatter, what is the practical impact of these constitutional tests for businesses on the ground?
Well, I think the answer is that as for the most part, as public health experts are setting policy, they're doing so through guidance as opposed to a set of immovable rules and regulations. And so seeking out that specific guidance that's unique to your particular business and following that makes sense. At the same time, I think it sets a standard for when a business that might, as a matter of politics, disagree with a particular order, or because they're concerned that it's going to hurt their bottom line. It gives them an idea of when it makes it appropriate to seek legal counsel and whether or not it's worth pursuing a challenge, and whether that challenge would be on a constitutional basis or an administrative basis. The goal of the proposal that I'm making really is to try to strip out as much of the politics to add rigor, and specifically medical or public health rigor to the test.
Thank you. Sorry, we're having an Amber Alert. My phone number is in St. Louis. The Amber Alert ambushes my technology. Professor Watson, what are the particular issues in this pandemic that have challenged the traditional for-profit healthcare system, and how would your proposal help?
Well, my proposal would help in the sense of strengthening Medicaid and strengthening states' abilities to maintain Medicaid during a crisis. I think for all healthcare providers, this is a time where we see demands in the emergency room, demands for COVID testing, what have traditionally been money-making pieces of healthcare, non-emergency outpatient services have dropped. So this is simply another way to realize that we are in a different healthcare delivery service time during this public health crisis, and realizing that we need to figure out how to support care for people who are losing employer-sponsored coverage and need a safety net to fall into. And if we can provide Medicaid coverage, that means not only will an emergency room be able to get payment if they get sick and end up in the emergency room, it means they can get the whole package of services that Medicaid covers, and that's going to strengthen all areas of our safety net and our healthcare system.
All right, so this question, I'm going to toss this up there. This might be an actual question for Dr. Rutschman, but if either of you want to give it a shot. Has the federal government short-circuited the intellectual property aspect by buying these vaccines in large quantity in return for a waiver of IP rights?
Yeah, I'm sorry that I can't help out with that question. I just don't know enough about the intellectual property rights or the framework.
Okay.
And that's why we're so pleased to have Anna Rutschman as part of our faculty. And we're sorry she couldn't be here today.
All right, for this next question is for Professor Watson. Under Section 6008 of the Families First COVID Response Act, do states have the option to accept the 6.2% FMAP increase and comply with the related conditions?
Yes, I see that question came in from Linda Racklin, who teaches at WashU and who's one of our LLM graduates. It's nice to have you here today, Linda. It is optional. It is voluntary. States do not automatically get the 6.2% increase. They have to say, we want it, and we will agree to the two conditions that we will not cut eligibility and enrollment, and we will cover COVID-related services at no cost. What's interesting about that is it avoids any issues that are raised by NFIB Sebelius. It's not required of states, it's not mandatory, it is optional. And therefore it would withstand, I believe, any constitutional challenges.
All right, this next question is for Professor Gatter. Which test, if any, should be used to evaluate a state's action that goes against the best available medical evidence? For example, a state that has a prohibition against mandatory masking or state mandated in-person education.
Oop, can you repeat the lead into that question?
Which test, if any, should be used to evaluate a state's action that goes against the best available medical evidence?
I guess my answer is that it's not so much a matter of the level of scrutiny. So whether it's a strict scrutiny test, an intermediate test, or it's the lowest, the rational basis test, if the administrative action that's taken place is inconsistent with the best available public health information, then under any test, that standard should fail if we are applying the lowest level test, the rational basis test, with sufficient rigor. And I think too often what happens is this idea that once a court has decided that only a rational basis standard applies, the court stops working with the rigor that's at issue. It's accustomed to the standard deciding the case. But when we're in a circumstance where we're relying on a particular expertise and in a particular emergency, a public health emergency and public health expertise, the test can very rationally be applied in such a way as to require that the evidence at least be supportive, that the public health evidence, that which is available, is at least supportive of there being a rational connection between the action that the state took and its goal of preventing the spread of a disease. Which test should actually apply is less a matter of what my presentation was about. Personally, I am not at all convinced that the Jacobson test is the right test, and that instead I think traditional standards for strict scrutiny in the cases of fundamental interest should apply, and lower standards where we're not talking about a fundamental liberty interest. But I prefer to focus in on the fact that judges need to apply a certain level of rigor even after they've decided the standard, and not reserve that rigor for when it's only strict scrutiny.
Thank you. Professor Watson, what immediate short-term and long-term impacts on Medicaid would result from a successful repeal or challenge of the Affordable Care Act?
Well, if the Affordable Care Act was repealed, the Medicaid expansion for low-income adults would go away. And about going into this pandemic, that would have meant loss of coverage for about 12 million Americans. Today, that number is much higher. So there is an absolutely immediate impact. Without the language in the Affordable Care Act authorizing coverage for adults between 18 and 64, the only way states had legal authority to cover adults was if they were permanently and totally disabled parents. So that means without the Affordable Care Act, there is no way for a state to cover a 55-year-old person who's been working in retail and loses their job and loses their employer-sponsored insurance. It would be devastating.
Professor Gatter, this is a question for you. Some healthcare organizations have needed to move into crisis capacity when faced with dwindling resources during the public health emergency, for example, beds, ventilators, drugs, PPE. How might your focused rational basis be applied to a state action that allocates a scarce resource from one class of persons to another? For example, ventilators away from the elderly towards younger patients.
Yeah, that is where we move into more of a political issue. I think that it's not purely then about medical information. To decide by what criteria should we ration scarce ventilators or scarce PPE or scarce medications, or, as we'll find hopefully in the near future, scarce vaccine as it's being developed, isn't purely a medical question. So then it does invite much more of a consideration of what other aspects of public policy ought to fit into this, including things like, well, where are our hotspots? Which segments of society are most vulnerable and who are experiencing the greatest degree of incidence? So when that happens, I think it's not purely about the medical evidence, but where we are instead taking an action that's designed to prevent the spread of a disease, that should be tied to such public health evidence. It's a great question. This exact issue has been tested. It's been tested primarily through challenges under the Americans with Disability Act, and the Office of Civil Rights in HHS has issued guidance when faced with claims that certain triage-like policies developed by states seem to be favoring the able-bodied over the disabled. And that's an appropriate place for those sorts of political matters to come into to be taken into account. And I should also mention that these actions, the ones that have been challenged, that have been reviewed by the Office of Civil Rights, is not really a constitutional challenge. Instead, it's being challenged under the Americans with Disabilities Act, and the agency is taking a position as to how the ADA applies in that circumstance.
Okay, thank you. It looks like we have time for just one more question. We have 2 minutes remaining. This is a statement with a question. There are some things we could do to reduce the number of folks suffering every day from chronic diseases that challenge healthcare facilities and the public, with particularly greater impact on certain populations, including Black, Brown, and people of color, in non-pandemic, let alone during this pandemic. The challenge is to invest in communities to deal with the social and structural determinants of health, including structural racism, in order to work on these going forward. Right?
Yeah, sure, I'll take that one. Ready? Here's my answer. Amen. Amen to that. Sidney and I have a colleague here at St. Louis University Law School, Rakaya Yerby, who has been writing on structural racism, and specifically has been writing on structural racism and what we're seeing in St. Louis and across the country that demonstrates how the spread of the disease, the impact of the disease, reveals the embedded racism that exists in the law and in culture, simply by looking at the disparities. I encourage everyone to go on to the City of St. Louis's COVID website, or you just go onto the city's website and click on its COVID information, and there's some maps there. And you can see in those maps where the incident per 100,000 people of COVID infections has occurred the most. And then jump over to the city has wonderful maps in which by zip code inside the city's borders, they have indices for social vulnerability. And that could be things like a lack of access to transportation, percentage of households falling below the federal poverty line, percentage of households with one or more individuals in it who are experiencing a disability, and other factors, including things like the number of residents in the area who are over the age of 65. And what you will find is that the same circle you might draw around the North St. Louis zip codes are the ones that are experiencing multiple aspects of social vulnerability. Those did not arise, of course, before when we had our first incident of COVID-19 in the city or in the state. Those are pre-existing. And it is almost like the disease has been the special ingredient that you add to a secret message that's already on the paper that you can't see until you add the special chemical on top, and then it reveals the secret code. Well, this disease has revealed what already exists in the city and just how much the disparities affect health, affect susceptibility to poor health, and are exacerbated when we have an emergency like this.
Well, I see that we're at 2 o'clock, so I'm going to turn it back over to Mike to take us home.
All right, well, like you mentioned, this is the end of our time together. I just want to take a moment again to thank all of our panelists for making the time to share their expertise and experience with us today. It's been very helpful, insightful, and timely. Thank you so much for everyone who was able to join us. We hope you enjoyed the panel, and we will be following up with an email with a survey for your feedback. There will also be a link to give to the Center for Health Law Studies, who put on today's CLE, and please consider a gift in support of the #1 health law program in the country. We hope you consider joining us next Tuesday, September 15th, for our next installment in the series highlighting social justice issues, and a link to register will also be included in that post-event email. Thank you all again for joining us today, and I hope you have a great rest of your day.